High drama in the courthouse that after Dean Skelos was sentenced. Our own Dominic Carter was there.
And good evening, Richard. A tough and emotional day for the Skelos family.
Come on, let the man move.
First, Dean Skelos arrived for his day in court, sentenced to 5 years in prison. A short time later, Adam Skelos, 6.5 years. Father and son choked back tears, each addressing the court, describing remorse and embarrassment. But Judge Kimber Wood made clear the direction she was going right out the gate. To Dean Skelos and the push for Skelos to instead receive community service, Judge Wood said, quote, "Your push for community service, you can teach others in prison." She went on, "Your crimes were more egregious than most, with the exception of Sheldon Silver." To Adam Skelos, the judge said, "You were corrupt and your father's legislative action could be bought."
Today should be the sentencing of former Senate Majority Leader Dean Skelos should send a clear message to elected officials across New York State that the days of using your public office for private gain should be over. If you do that, you face time in the slammer. And it's about time that Albany started to get cleaned up.
U.S. Attorney Preet Bharara was again in the back of the courtroom and released a statement that was a clear slap at Governor Andrew Cuomo and a warning for the future. Quote, "These cases show and history teaches that the most effective corruption investigations are those that are truly independent and not in danger of either interference or premature shutdown. That will continue to be our guiding principle in exposing and punishing corruption throughout New York." Richard, let's now take a look at some video from earlier today. This was the scene as Dean Skelos was leaving. A mob situation surrounded by cameras, upset family members at the prison time that had just came down, and apparently a nephew of Dean Skelos got into a pushing and shoving match with a reporter, took her phone and threw the phone. That was the situation a little earlier today. That is it for now in Lower Manhattan. Reporting from the federal courthouse, I'm Dominic Carter. Richard, let's go back to you.
Thank you, Dominic. In fact, that cousin was arrested and charged with a misdemeanor. But let's bring in our panel right now. Jim Kastouris. Jim is a criminal defense attorney in Manhattan, sitting on the board of directors of the New York City Criminal Bar Association, frequently lecturing at New York Law School and the bar associations in Queens and New York City. Former federal prosecutor Robert Ray joins us. He was also independent counsel for the Whitewater investigation. And to his right, Mark Furnish, a professor at Brooklyn Law. He's argued before the U.S. Supreme Court and, like me, a despondent Islander fan. All right. There was a motion there was reportedly Dean Skelos' wife leaned over and said some unpleasantries to Mr. Bharara about the case. But nonetheless, Rob, give me the idea. Many people thought if Silver got 12 years, Skelos would get something similar. He got 5 years, I guess, and his son got 6. Were you surprised by the sentence or the disparity between the two? I know different cases, but still about corruption.
I suppose maybe a little surprised, but when you read and considered what Judge Wood took into consideration in deciding how much time was appropriate, consistent with the interests of justice, I think she made a fairly persuasive case that, there was a measure of mercy here for the fact that Dean Skelos did at least in part what he did as the result of trying to help his son. I think, frankly, probably the most determinative factor is that the amount of money involved in connection with the Skelos case wasn't near the same amount of money that was involved in the Silver case.
Was it the cumulative, evidence that this was, a corrupt endeavor, that not only was he trying to place his ne'er-do-well son with jobs here, but he was trading his office? Was it more the cumulative, or was one particular piece of evidence that was most damning for the Skelos?
There were aspects of it about this particular case where you talk about aggravating factors, and they came, essentially from the evidence that was introduced at trial as a result of the wiretap. So you had a more candid assessment of what these two individuals were actually thinking because their conversations were recorded. I think that was an aggravating factor, and that, in fact, I think in part explains why the sentence against his son was so severe and indeed actually higher than his father.
And you're very charitable by saying thinking, when at one point in the recordings they said, hey, they're probably listening to our phone calls, and then they continue to go on and talk about the criminal enterprise.
I don't think that helped at all.
No.
I mean, Judge Wood picked up
You're
that,
a
on
kind
that
man.
Right away.
The burner phones also.
Yes, yeah, burner phones, exactly.
The evidence against Skelos was much more damning and inflammatory than the evidence against Silver. But Silver's offense was far more egregious because it directly affected public money. He was using his office to funnel taxpayer monies to the doctor
And
in
the
question.
scope here, and the numbers that we're talking about in the millions.
Here he was usually, Skelos was really using his office in a bully fashion to benefit himself and the son to get things he wasn't entitled to, but it didn't jeopardize public funds directly like the other cases.
I always go to you, Mark, on Supreme Court issues, and in this particular case, the judge directly referenced something going on at the High Court that could impact this, and I think it also gave the rationale as to why they were released, both of father and son today. Judge Wood referenced...
She doesn't know whether she's going to release him on bail pending appeal yet. They'll brief that, but the McDonald case does potentially
In fact,
impact.
her exact words, I want you to explain why. She said, there's a danger this case may be decided by a rationale that will be rejected by the Supreme Court, obviously relating to the Virginia governor.
Yeah, and that will be that he ostensibly didn't commit any official acts. He didn't put his thumb on the scale, the elder Skelos, with respect to any government decisions. And that's very much a live issue in the Malcolm Smith appeal that I have pending right now.
And it was argued just a couple of weeks ago, and the Supreme Court, many members of the Supreme Court.
Tough day for the government, but you know, you don't always know how it's going to turn out based on the
Okay, but
argument.
this comes down to, I guess, the definition of corruption. I'm sorry, but if it smells like it and it looks like it, he clearly was trading his office for favors. Favors to get his son a no-show job, or a job that he decided to no-show, whatever you want to call it. But he traded his office for that. He used his office to leverage who would get contracts, etc. Why isn't that by definition corruption, and why is that not a violation of public trust?
Well, the McDonald case addresses the issue of, from a legal standpoint, you have to commit an official act within your capacity in order for it to be public corruption. But you know, the McDonald case, this case, you know, what we're really talking about is what is that threshold of acceptable corruption. You know, what is corruption to us in a
Just think how
normal
perverse
sense.
that sounds,
well,
but
no,
it's
no,
true,
but you think about it. What you're right. It smells bad. It's unseemly. It doesn't sound right. But it may not be a violation of law, and that is really what the Supreme Court is.
Everyday politics.
No, but you see, I understand.
Something is unethical doesn't mean it's criminal.
I get that, Robert, and I get where Buffalo, for example, on its face, and it's very premature, so I'm not reaching conclusions, but was he a consultant? Was he under the employ of the governor?
Right.
How did the contract work as it relates to who got awarded the contracts, who was getting consulting fees? That is a gray area. Still doesn't look right or smell right. But in this particular case, this was overt. Do you believe the Supreme Court that what McDonald did and what these two did in Silver and Skelos are apples and apples, or are they two different
Well,
answers?
let's start with some things we do know. I mean, there's no question that both of these cases, Silver and Skelos and others, represent an abuse of the public trust. And
is that criminal?
And an abuse of power. Well, that's the question. I mean, you know, there may be crimes that have been committed, and some of them may, for example, be state crimes. But you're talking about federal prosecutors coming in and prosecuting cases under the federal mail-and wire fraud statutes for you know, failure to abide by their obligations to provide honest services to the public. And a related wrinkle to that, which is whether or not they extorted under color of state law their office. Those are, you know, federal crimes. A federal prosecutor is coming in to prosecute state governmental officials. And the Supreme Court has recognized that there's some real question about, you know, federalism and respective power between the federal government and the state governments, about, you know, who frankly should be responsible for prosecuting these kinds of cases. So,
and to that end, we're going to talk next segment about Preet Bharara and the powers of the U.S. Attorney and who polices the policeman, if you will. But does this also indict in some ways, Jimmy? Where have the DAs been in this case? Where has the Albany DA been? Why does this always fall, whether it be to, or for that matter, where's Schneiderman been on this? It took a U.S. attorney to get involved. I don't think anybody says, we'll get to all the grandstanding if people want to call it that, but things stunk in Albany. Finally, somebody said, this is not doing the public's will. We'll see if it's upheld at the Supreme Court, but nonetheless, have other folks dropped the ball before it got to Bahara's desk?
Well, you know, you say, why did it fall to Preet Bharara? It didn't fall to him. He made a decision to use federal laws in order to prosecute what he believed to be crimes in Albany.
But state prosecutors could have also gotten involved if they chose to.
Absolutely, they could have. And to Robert's point, it just may very well be that the conduct here falls more squarely within state statutes as opposed to federal statutes. And he's testing these statutes.
Well,
he's
there
testing
are ample
every one of
state
them.
statutes that could punish this conduct. The rationale for federal intervention is that the local politicians, elected district attorneys, are too close to the matter to do the job justice. So Bharara asserts a federal interest, a tenuous federal interest, because after all, there's no such thing as a general federal police power. Enforcing the laws is a classic state function. It's Bharara's view that they're too biased and too close to the situation on the ground to do anything about it. So he steps
Also his
into
view
the
that he
breach.
wants it.
I got to
Well,
jump
of
in.
course he wants to be the
And
governor
that's a
or the
perfect
mayor.
point to
There's very
pivot
little
to a
doubt
break,
about
because
that.
when we come back, Preet Bharara is now 2 for 2. That after his office obviously took down Silver and Skelos, 2 of the 3 men in the room, and we also know that there's an investigation going on with the governor as we speak. So the question is a powerful prosecutor all good here, or are there any questions as to maybe there could be some unchecked power? We'll get into that with our next guest after this.